I think the first thing I have to acknowledge is that you effectively have the current recorder and the previous recorder, and I always feel like he's still my boss. So it doesn't really help for me to think of myself as having escaped you as my line manager, because I still think of you as my boss. Look, first of all, I'm absolutely delighted to be able to speak to you. The reality is that as recorder of the city, it is my intention to be the recorder of the city for everyone. And that involves visiting a number of the resources that there are and the partnerships that we have in criminal justice. And the first point of call was the first place I absolutely wanted to go and see was the FJC. And the reason why I wanted to go and see the FJC is, as Tom has already pointed out, I was appointed as a district judge magistrate deputy at 40. I was reasonably young, but Barney McElhone was my mentor. Now, when Barney started talking about non-fatal strangulation, as my mentor, I thought, do you know what? Actually, if Barney's talking about it, I should be listening. So I started doing my own work, my own research. And quite frankly, what I was reading was appalling me. Because for far too long, things that I had encountered as a practicing criminal barrister that really had been dismissed or not considered actually were some of the most appalling red flags, and we were missing them all. And when I went to the FJC, I think Mary will tell you, I didn't get past the door for 30 minutes because a lot of the workers in the FJC I met, shook hands, and immediately the question was, look, what are you guys doing about this? We're here at the coalface. What are you guys doing about this? And I told them chapter and verse on the authorities and so forth and all of the things that the judges were actually doing, which hadn't filtered through. And the penny sort of dropped. And I'm not being political, but in the absence of an overarching strategy for violence against women and girls, which creates a nexus for information sharing between partners, we're all left working in this field, thinking no one else is getting it. What's anybody else doing? And we're left feeling disempowered. We're left feeling, look, why am I knocking my pan in against a brick wall and nobody is listening? And the reality is, we all are working in our own small corner, but because there's not a joined up information sharing platform, none of us know what anyone else is doing. I can sit here and I can say, hi, Angie. Angie and I, she works in DOJ, I'm the tutor judge. We've talked about this on numerous Zoom calls through the pandemic. We know what we're doing, but that's only because of that encounter. I can say the same to Geraldine. Hi, Geraldine. We can discuss that. But that's why I went for this topic. And by the way, there could be a trigger warning later on. I don't mean to upset anyone. I really don't. But I need to get something across to everyone before they leave here. The question is, what are the judges doing? Well, that's easier to explain in abstract. In the language of policy and administration, you all work in various organisations. You understand policy, you understand implementation. Well, I'm going to talk about 3 cases. And they're not the only cases, but I think they actually bring something to the table. And it'll illustrate, hopefully, how the judiciary implement policy and implementation. In the judge world, policy is the Northern Ireland Court of Appeal, who set the policy. Implementation is largely done by Crown Court and Magistrates Court judges. And there are three cases which I am going to highlight. And they are Campbell Allen, Hutchison, it's actually Hutchison, not Hutchinson, my typo, and the King against BN. And Louise has already stolen some of my thunder in BN, but I'll come back to it because there's actually stuff in it that Louise didn't touch. I think it really is necessary to point out Campbell Allen and BN are non-fatal strangulation cases. Hutchison is a femicide. If we can go to Campbell Allen, and I apologise for the small print of this, it's information dense. The terminology and concepts of family tiffs or lovers' disputes relied upon by Mr. McConkie are simply not appropriate in the context of domestic violence. These concepts diminish culpability by suggesting that it is only a domestic incident, or by excusing the offender on the basis that he or she is not normally violent. He continues, "We repeat again the consistent approach of this court that the domestic context is a significant aggravating factor." And what about good character on the part of the defendant? Well, domestic abuse goes unnoticed for lengthy periods. The ability of the offender to have a public and a private face, so that an offender's good character in relation to conduct outside of the offences will generally be of no relevance. Two important things are being said there. The language surrounding domestic violence, that it can be dismissed, is not appropriate. It will never be something that a court will take into consideration because it is simply not appropriate. But more importantly, the recognition, the street angel, the fireside devil, the domestic setting of this particular offence type, the public face. How many times have we heard in a femicide the neighbour talk to? He seemed such a nice man. The good character of a defendant in a domestic setting is of little relevance. Campbell Allen continues, and this is really strangulation is a form of asphyxiation. I have to say, I was absolutely delighted to see this as I came in, because it raises awareness of what we're looking for, which is really important. And I'll come to that in BM. This is important. Strangulation is an effective and cruel way of asserting dominance and control over a person through the terrifying experience of being starved of oxygen and the very close personal contact with the victim, who is rendered helpless at the mercy of the offender. The intention of the offender may be to create a shared understanding that death, should the offender choose, is only seconds away. The act of strangulation symbolizes an abuser's power and control over the victim, most of whom are female. Just let that sink in. We can talk about domestic violence, and it is important to remember that males are the victim of domestic violence too, so that is an awareness, but not overlooked. The overwhelming majority of domestic violence is gendered violence by males on females. And asphyxiation is an aspect of that. This is where I'm glad Louise mentioned the genesis of the 1861 Offences Against the Person Act, This is where our Victorian forefathers and mothers got it absolutely wrong. Absolutely wrong. Because they were cause and effect people. They couldn't fathom that anyone would choke anybody without a purpose. We now know that the real purpose is to engender terror. It is as a weapon in a domestic setting for coercive control, and that its real purpose is that it is the purpose of terrorising. The Right Honourable Lord Stevens of Creevy Lough Ger was the author of that judgment. He is currently the Northern Ireland judge on the United Kingdom Supreme Court. The next judgment is Hutchison, and I apologise for the typo. This is a femicide case. The starting ranges for homicide contained in the case law has the lower starting point at 11 years, where there are no aggravating factors, and the higher starting point of 16 to 17 years, where there are aggravating factors. In this jurisdiction, we are now more alert to the scourge of domestic violence, which has become all too prevalent in our society. It is particularly striking in this case that there is a repeat pattern of domestic violence which escalated to murder. This sentence reflects and recognises society's utter condemnation of such behaviour and should be taken as a signal that offending of this nature will attract commensurate sentences. That was an appeal to the Northern Ireland Court of Appeal on a life tariff where the minimum sentence to be served was 21 years, which is 5, 6 in excess of the starting point where there are aggravating factors. And the Right Honourable Dame Siobhan Keegan, Lady Chief Justice of Northern Ireland, who I am proud to say is the first Lady Chief Justice on these islands. And the reason why I'm showing you both those photographs and who they are is we don't have any heavier judges than that. You have the Northern Ireland appointee to the Supreme Court, and you have the Lady Chief Justice in this jurisdiction. And both are responsible as the authors for strident judgments that I have just read to you, setting out exactly how domestic violence and how non-fatal strangulation is of serious import in the judicial world. The next case is BN, and since Louise has already outed me as the author of this, there is no photograph of me. You will be delighted to hear. This is a guidance judgment. This is a judgment that is written by a county court or crown court judge like me. It binds nobody. But hopefully it does set out the process by which you might like to go through as a judge if you come across one of these cases. The gravity of non-fatal strangulation is increasingly becoming identified within the courts and broader society as a significant area of concern. I touch upon Section 28, creating a freestanding offence. The research and clinical evidence of which this court takes judicial notice is stark. The act of strangulation itself, often as Miss McDermott KC has called in aid, produces very limited direct physical injury. Conjunctival hemorrhage, petechial hemorrhages, and faint bruising on the neck are often the only observable injuries after what may have been a terrifying ordeal. The significance of these injuries should not be underestimated by investigators, prosecutors, or indeed the courts. Now that's an important enough little paragraph. When a judge says, I take judicial notice, that means you haven't heard any evidence about it. But I'm the tutor judge for Northern Ireland, and I do a lot of the clinical research with people like Kath White and so forth. And when a judge says judicial notice and puts it in a judgment, it's there, and it's there for other judges then to reference and simply draw across into their own judgments as this is important. The next paragraph is where I deal with the research in that judgment. Research has clearly shown that often very modest pressure exerted upon the structures of the neck, the carotid artery, the jugular vein, and the trachea have a terrifyingly quick action. Indeed, the accepted timeline for strangulation is that at almost 7 seconds, it's actually 6.8, the victim will lose consciousness. At 15 seconds, bladder incontinence may occur. At 30 seconds, bowel incontinence may occur. Cell death occurs between 2 and 3 minutes, with brain death between 4 and 5. The significance, as occurred here, of bodily incontinence occurring in a case of non-fatal strangulation is that the act of strangulation continued beyond where the victim would have lost consciousness. Now, this is the trigger alert. Would you just gently put your hand on your neck and close your eyes for me? 1, 2, 3, 4, 5, 6, 7. You are now unconscious. 8, 9, 10, 11, 12, 13, 14, 15. You may now have soiled yourself. 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30. You may now have defecated. Just open your eyes. I hope you agree with me. Do you remember victims would tell us that it may have only been minutes, but it seemed to last for hours? 7 seconds is an alarmingly quick time to become unconscious. But the remaining 23, where someone is lifeless, putting up no resistance, is unconscious, and yet the strangulation continues. That's what I'm getting at when I say that we really have to take this seriously. In BN, I want to pay absolute... I noticed Anthony was talking about training the young response officers. Look, hats off. You're X number of years of age. You get into the PSNI, you go through Garnerville, and you're deployed immediately as what's called a response officer. The call sign is 70, 71, 72, 73, depending on how many response units there are. In BN, the young response officer arrived, was told by the victim, look, I've soiled myself, I've cleaned myself up, and I threw the track bottoms and the pants into the bin over there. And the response officer went, there's no bin. Where's the bin gone? He then conducted a search, went outside to the wheelie bin, and recovered the feces and urine stained underwear and tracksuit bottoms and put them in a evidence bag because they had been concealed by the defendant. So, let that sink in. We need response officers to recognise what they may otherwise think of as, oh, this person's drunk, they've wet themselves. Can actually be a major statistical red flag. This is where I draw the conclusions together. I am satisfied that cases involving choking or non-fatal strangulation, there are a number, or on a case-by-case basis, but there are a number of principles or matters which should be considered. Non-fatal strangulation must be clearly understood as a very serious offence in its own right. It is a terrifying experience by any victim, and deterrent sentences are required. Deterrent sentences are the sentence we impose not just to punish an offender, but to send out a message and deter others. Secondly, non-fatal strangulation in a domestic setting must be carefully examined by police, public prosecution service, Probation Board for Northern Ireland and the courts. It is a statistical red flag for femicide and operates at all levels in the assessment of future risk, which is one of the Milbury principles of sentencing. It is also a significant impact upon the question of dangerousness. Now, what am I saying there? Dangerousness under the 2008 sentencing order came in after Atracta Haran's murder. There is an assessment required to be made in every case which is either a serious or a specified offence. Non-fatal strangulation is a serious offence, so the question of an offender being dangerous needs to be assessed. The context is that he is committing an offence type which is a statistical red flag for femicide. And that's where I am saying there that our colleagues in the Probation Board for Northern Ireland need to factor this in to their risk management assessments of offenders in this space. Going on to the conclusion. 3, as noted in Allen, non-fatal strangulation may often result in little or no observable physical injury. This does not equate to low harm. When we sentence people, we divide cases into cases of high harm, culpability, harm, future risk. The harm is assessed as either high harm, moderate harm, or low harm. Traditionally, when you get no physical injuries, unless there's a psychiatric report to say that the person is seriously affected, it is regarded as low harm. What I am saying there is that the terrifying and potentially life-threatening nature of non-fatal strangulation requires to be properly understood. In addition to any physical harm, mentally damaging trauma and harm can largely be assumed, and accordingly, high harm applies. That puts it into the highest bracket because of the terrifying nature of it and the likelihood that it will affect someone for the rest of their life in terms of how they're having to deal with that aspect of their life. Lastly, the physiological sequelae from choking and non-fatal strangulation, which in respect of incontinence of urine and feces, or both, must be understood, and it is connected with duration. Therefore, it is a significant aggravating factor. That's what I've chosen to do. Allen, Hutchison, and BN. And the reason why I've chosen to do that is to let you see that there is a pretty comprehensive policy and implementation across the judiciary. Non-fatal strangulation, domestic violence are significant aggravators. You may not always hear about it, and one of the reasons why you may not always hear about it is because, dare I say this, in their lords and ladyships, but the Northern Ireland Court of Appeal doesn't get on the front page of the Belfast Telegraph. It gets into the law reports. And then when someone like me takes the time to write something like BN, you're wondering what's the name of that person? The King against BN. Well, there was a sexual offence involved in that as well. A victim of a sexual offence is entitled to lifelong anonymity, so therefore any judgment we produce has to be anonymised. What do we know about the Fourth Estate? They love nothing more than Joe Smith from Camber Street was convicted of X, Y, and Z. It's not so good a story. A man who we cannot name for legal reasons did something awful that we can't tell you about and got 6 years for it. You know, this is where we actually need the overarching strategy to have the portals for exchanges of information. And this is why I've chosen to speak to you about this particular area. And that's why thank you for giving me the opportunity and affording me what I regard as a very important opportunity to let you see that judges do not live in ivory towers. We are not out of touch. Sometimes we're the most in-touch people in the area that we work in. We just never really get the chance to show you that. Thank you so much.